Well, thank you very much to everyone that has joined us this morning for this webinar on class actions versus group proceedings, thoughts from Australian perspective. Three main speakers, presenters today. My name is Stephen Goldie. I'm the partner at Brodies. I was in charge of litigation, head of litigation there. Brodies is a full service law firm, as I'm sure many of you know. We have 150 people in the litigation department alone, covering all sectors of the economy. And of course, class actions, group proceedings can cover all those sectors. Our speakers today include Craig Watt. Craig is a partner and solicitor advocate at Brodies. He specialises in class action work, and he'll say a bit more about that as we set the context for this particular session. Joining us from Australia, first of all, Mike Hales. He has more than 25 years experience in commercial litigation in Australia. He is based in Perth. It is 4:30 p.m. in Perth, so it's just coming up to dinner time for Mike. But I think that it's also worth pointing out that Mike has recently been asked to take on the office managing partner role for Perth, the Perth office, or indeed Western Australia for MinterEllison. MinterEllison is a leading Asia Pacific law firm. It is the largest law firm in Australia, and we have worked with them in the past, so we have some links with them, so we know just how good they are at what they do. Also joining us from Sydney in Australia is David Taylor, a partner in the dispute resolution team at MinterEllison. David also specialises in class actions, and it's 7:30 p.m. For David, so not quite past his bedtime, but he's getting there. Right, now a bit of content before we get on to the main presentations. Class actions globally are on the rise, and this is something that we find ourselves advising clients more and more about, not just about the classes which form and go into court, but also just being on the radar for potential classes, so trying to help clients mitigate the position before things end up in court. So without any further ado, I think I'm going to pass you on to Craig Watt, and he's going to set the scene in Scotland for the current position with class actions and group proceedings. Craig.
Well, just to provide some context in terms of the Scottish perspective, well, talking about group rules that come into force in 2020, it brings many folk out in a cold sweat. I've got images of counting people in my back garden as they huddle beside the patio heater. But I'm not talking about the COVID restriction rules. I'm talking about the long-awaited group claims or class actions procedure rules that came into force in Scotland on the 31st of July 2020. So for the first time, groups of two or more people with the same, similar or related claims have a mechanism through which to raise proceedings together in a single action in the Court of Session in Edinburgh. For some years prior to those new rules coming in, the courts had worked effectively a workaround effectively to try and allow people to group together to try and ensure efficiencies of progression through those through the court of those actions. For example, I'm thinking about the personal injury claims such as the vaginal mesh claims, which went through the Court of Session, where parties chose test cases to run first, and for all of the other cases to put on hold pending the final decision in that test case. In a more commercial context, there's been some pensions cases that have gone through the commercial courts where they were of similar facts, but several pension schemes operated by related employers. Those cases ran in tandem with one proof and one decision issued, but dealing with the separate facts found for each of the 6 cases. But it's fair to say that there's been a demand for a proper system of running cases together in groups, and we now have that in Scotland. So what changes did the rules make? Well, the rules implement Part 4 of the Civil Litigation Expenses and Group Proceedings Scotland Act 2018. That introduced group proceedings on an opt-in basis. This means that potential class members must elect to join a class in order to participate, as opposed to the US, or as I understand it, and David will cover this, in some cases, the Australian system, where they have an opt-out ability to proceed as a group. So how are group proceedings raised in Scotland? Well, as well as the usual summons to start a claim, what you also need is a group register, which listed all of the pursuers who are forming that proposed group. And that's considered very crucial to the operation of group proceedings in Scotland. The practice notes from the court are suggesting that it's the key to the success of the procedure and the administration of the group by the court. It must be in full form, the group register, and it must be updated to keep details of all of the members of the group following any changes to the group's membership at any instant time. So the summons, the group register, and the core documents must be lodged with the court, and this can only happen once the documents have actually been served on the intended defender. Now, once that has happened, the court will then hear a motion for formal service of these documents, the summons, the group register, and the core documents again. So there's effectively two requirements for service upon the intended defenders before the court will then hear applications. Now, those applications are twofold. One is for the appointment of a representative party, and one is for the applicant or the group to proceed by way of group proceedings. Now, in the Volkswagen case, which is one of the 3 group proceedings which have been granted in Scotland, the applicants made a motion for dispensation of the requirement for the second service, which was refused. So that what's becoming clear in this fairly nascent group proceeding structure is that the court will stick to the rules in place and won't very easily depart from what has taken some time to be imposed in the form of these new rules. Now, I touched upon there the application for the appointment of a representative party. That is the person who will be effectively authorised by the court to commence the action on behalf of the group. The court will consider a number of factors when they're considering that applicant's application. They'll consider the relevant expertise or special abilities of that representative party or the proposed representative party. They'll consider their interest in the proceedings and any potential benefit they will obtain, and that these do not conflict with the interests of the group as a whole. And they'll consider their ability to demonstrate sufficient competence to litigate the claims properly, including their financial resources to meet any costs awards made negatively against them. Now, the applicant needs to satisfy the court of their suitability to be a representative party, and it must be brought out in detail. It can't just be a repetition of what the court rules are stating that they must address. It must be bespoke, framed, if you like, that application. Now, as I said, a separate permission is required for the case to proceed by way of a group action, although this can be sought at the same time as making an application for the appointment of the representative party. Now, under the rules for group proceedings that are now in place in Scotland, the defender has an opportunity to respond to the applications at the start, and that is both of those applications, and it's possible to appeal against the grant or refusal of permission to bring group proceedings. However, it doesn't yet appear that it's possible for there to be an appeal against the authorization or I suppose refusal of the appointment of the representative party. So what types of claims can proceed by way of a group action in Scotland? Well, the principal requirement is that the group of claims must raise issues of fact or law which are the same as, similar, or related to each other. So that is effectively all-encompassing. The representative party must be satisfied that each group member's claim falls within that group class and that the individual claim has not prescribed. It's possible to add group members as the matter trundles forward to a proof, or as I understand it might be known in other jurisdictions, a trial, or the court closes the group. Now, the court must also agree that there's a prima facie case that proceeding as a group as opposed to as individual claims will be more efficient. And finally, that there's a real prospect of success. So that's a very brief canter through where we are now in Scotland. I'd be very interested to hear how that differentiates in Australia.
So thanks, Craig. I mean, one of the reasons why we have teamed up with MinterEllison on this topic you can see from Craig's overview of Scotland that it's quite a new breed of claims in Scotland. Before the new rules came into effect about 18 months ago, if you had a whole load of claims essentially chasing the same sort of fact, circumstances, legal basis, individual claims had to be raised for all those. So if you had, hundreds of people with more or less the same claim, you would often find that the sheriff court would get clogged up with a whole number of claims. And sometimes a number of those claims were paused while a principal lead claim went ahead. But this really gives the opportunity for all the claims to come under under one banner, under one heading. And the reason why we've been speaking with MinterEllison about this is in Australia, in particular, and indeed the US, group proceedings or class actions have been on the go for a lot longer. So we thought it'd be useful if we could try and take some of the learnings from Australia. So on that note, could I just pass you over to Mike Hales, who's going to give us a bit of an overview from the scene in Australia. Mike.
Thank you, Stephen. Good morning, everybody. Australia is the second most active class action jurisdiction in the world after the United States. So there is a fair amount of experience here about how our class action system works. We won't go into the detail of our process, that's not relevant, but what David and I hope to do is in response to questions and through some introductory slides, just draw out the highlights of how it works down here and give some points to think about that might be relevant to you in Scotland. So in essence, this slide outlines our procedure. It's important to realise that Australia has both a federal government and also separate state and territory governments. Our principal class action legislation is at a federal level, and it got introduced in 1992, and it's been followed slowly, it must be said, but it's been followed slowly around the country in the various state courts. You can see, for example, that in Western Australia, where I'm based, the legislation has only come in this year, and in fact, the procedural rules are not yet available. So we don't really have it in Western Australia, but that doesn't matter very much because most of these actions are fought out at federal level in any event. So the requirements in Australia in outline, you need to have 7 or more claims against the same person. I'm intrigued about why it's 7 and not 5 or 10. It just seems to be an odd number. I have no explanation for that. And in fact, you don't really need to identify all 7 precisely, so long as it is clear that there will be 7 or more. That's very rarely an obstacle. Equally, although the rules say that it should be against the same person, it is possible to have more than one defendant. The second requirement is that the claims, all in respect of, arise out of the same or similar or related circumstances. But actually, over the years, the practice on that has become softened so that you need to have some major common issues, but there can be separate issues relating to various claimants beyond and surrounding that. And the question that the court considers is really similar to the Scottish one, is the class action procedure the most efficient way for resolving this particular dispute? And if there is a major common issue that links the claims, that will be enough to get the class action up and running. If there then have to be separate hearings to resolve particular issues that would apply to individual plaintiffs or individual groups of plaintiffs, then those can be resolved. But what our experience shows is that often, once the major point of issue in the class action has been resolved, that will tend to resolve the case itself and often leads to a settlement. It's important also to understand one major difference is that we are in principle an opt-out jurisdiction. So you're in the class unless you opt out. And one of the things we can discuss later is why you might want to opt into a class action in your case, or opt out in Australia, because they involve strategic and commercial issues, which will be relevant to you. But we do have now closed classes. Now, closed class is where a group of plaintiffs have signed an agreement with a particular funder. So the class will be described as people who've got a claim arising from X who have entered into a funding agreement with Y. Now, the closed class doesn't prevent other plaintiffs from pursuing their own claims arising out of the same issue. It just means that there would be a multiplicity of proceedings in relation to that particular issue. And one of the things that has been a feature of class actions in Australia over recent years has been competing lawyers and competing funders pursuing the same claims and trying either to be the lead case or at least to be co-plaintiffs in an action. If we could move on to the next slide now, please. So on the left of the screen, you'll see a sort of flow diagram, as it were, about how our class actions work. The first thing is the claim is identified by typically a plaintiff law firm, perhaps a funder. One of the very common sources of class actions in Australia is shareholder class actions, and typically what will happen is the plaintiff law firms will look for a significant drop in the share price of a company, and immediately they'll say, something's gone wrong with the company. When did the company know about this? And we have significant rules requiring constant disclosure to shareholders of material impacts on a company's performance. And it's very common for the plaintiff law firms to allege that a company did not announce bad news quick enough and has misled the market by withholding the information. Funders also look for new claims, and in particular climate change actions now are seen as being something that funders are looking for to see whether there are substantial damages actions that they can bring on the basis of climate change. So once they've identified the claim, the next thing for them to do is to identify the class and to try and get the class together. And then that's where we get into the opt-out or closed class issue. There is then a representative plaintiff who files the action on behalf of the class, and then we will go through the normal court procedure. There is very heavy case management in class actions, which David can come on to talk to in more detail. Probably the most significant thing that arises in Australia here is it is very common for class actions to settle, but the settlements have to be approved by the court. And that in particular brings in the issue of litigation funding. And the court does have the opportunity and the right to rewrite the settlement if it feels that the settlement is unfair to members of the class. Now, over the years, the cut sought by litigation funders has diminished as the funding world has become more competitive, and what used to be a range of perhaps 30 to 40% of damages going to the funder is now down within the sort of range of 20 to 30%. But even then, that might not be approved by the court. And what the court will do is look at the settlement and consider the degree of risk taken on by the litigation funder, the duration of the action, and in effect, the bigger the risk, the longer the duration, the more remuneration the courts will consider that the funder deserves. But as a rule of thumb, the court will not approve a settlement where the class members get less than 50% of the damages to which they would be entitled were there not a litigation funder. So that's how settlement works. If the matter isn't settled, then you'll go to one trial of the substantial actions that link all the claims, and then perhaps spin-off trials on the other. And then after that, there is a distribution of the proceeds. On the right-hand side of the slide, we put some of the most typical class actions we get. They cover the full range as you'd expect. But for us in particular, I think shareholder class actions probably has been what keeps us busy the most. And probably like America too, firms tend to either be plaintiff class action firms who will use funders and so on and so forth, or defendant, which is where we tend to appear. We don't tend to do plaintiff class action work. And whilst we don't have the contingency fees that are available in Scotland, except in Victoria, which has brought in its own statewide contingency fee rules, the litigation funding is really the key economic driver of our class action system. So that's all I wanted to say on that. I'll just hand over to David now.
Thanks, Mike, and good morning to everyone. Could we jump to the next slide, please? Thank you. I don't profess to be a Scottish group procedure expert. Craig's done a much better job than I could ever do in explaining the boundaries of that relatively modern procedure that you're grappling with. But what we thought would be useful was, and we've already touched on some of this stuff today, is to draw out some of the more important differences. And there'll be a discussion later on in this presentation where we can expand on some of these matters. So the first issue, and the one that's been touched on already, and Mike, as far as I'm aware, there isn't a reason why 7 was chosen that I'm aware of. I'm sure there's probably a discussion about it somewhere hidden in the depths of the regulations. There is a requirement of 7 or more people to form a class, but as has been touched on, you don't really need to identify those individuals in Australia. If it's more likely than not that there's going to be 7 or more people, that's usually sufficient. Very rare circumstances where there might be the sniff of a class action that is really down to very, very small numbers, would that be a matter of challenge? But if you have, for example, a shareholder class action where loss is brought on behalf of people who purchase securities in a particular period, it's very likely that you're going to be well in excess of 7 people. One other thing I'll note on this, because it was touched on by Craig a little bit, is the position of the representative applicant in Australia, or the representative plaintiff, depending on whether you're in the state or the federal jurisdiction. That's not it doesn't seem like, from understanding Craig's description before, in Australia, we don't have as stringent requirements for the representative applicant. Obviously, they've got to fall within the class definition, but as we'll touch on more, the class definition can be very broadly drafted. So as long as it's an individual who is likely to have suffered loss from some alleged wrong, they're probably a suitable applicant. Now, if that's not the case, and a defense firm wants to take a challenge that there isn't a suitable representative applicant, either that will be successful, that's very unlikely, or the judge will say, okay, well, I'll grant leave to appoint a different representative applicant, or the judge will say, well, that representative is somewhat sufficient, but I think a subgroup should be appointed in this class and we should have a different representative applicant for that group. But it's not a stringent set of requirements, unlike what I understand is in the situation in Scotland. The second main issue, and it's been touched on here, is touched on previously, is the matter of having one substantial common issue of law or fact. Now, I note that you have similar language in Scotland, but as Mike has touched on, it's somewhat more watered down in Australia. The purpose of this criteria is really to allow a judge to say there are some efficiencies in running this case in this manner. So, for example, a judge might say, I accept that there's multiple points of law that need to be resolved, but there is one big issue that I can resolve for multiple group members by running this case to a common issues trial before we have to spiral off into lots of individual trials and cases. That can be contrasted, for example, with the US system, where the requirement is for a predominance of common issues. And what that effectively means is you can attack that class if you find that there's lots of variances between the group members, which makes it much harder for those classes to get past the certification stage, which I'll come to in a second. The third item on this table is the opt-out model. Mike's touched on this to one degree already, which is, yes, technically the legislation in the state and federal courts in Australia require people to opt out of class actions. They're automatically in if they fall within the class definition. But what in practice has happened is two different forms of class actions. An opt-out model, which it's simply an open class. That is, an individual is a group member in a class if they have suffered some wrong from some alleged harm. An opt-in model has been sort of developed, although it's not called an opt-in model, by having a requirement for a third limb to that test. So an individual who has suffered loss from some unified harm and has signed a funding agreement, i.e. that last criteria requires the person to take effectively a registration step. It also requires them typically to have to agree to provide a cut of whatever settlement amount or judgment award they win. They give that to the litigation funder. Funder always takes a percentage of a return. But that's effectively become a form of opt-in model. And there's one other matter here in terms of opt-in and opt-out. We've also developed a system in Australia called a soft closure mechanism. Now, a soft closure mechanism is where you have an open class, so come back to the principles again, and a set of people who have suffered loss from some common harm being caused to them, alleged harm. That's a generally broad open class. But parties often mediate in class actions once or twice. And to allow parties to mediate and talk about exposure and damages claims and what they should be negotiating on in terms of dollar figures here, they reach an agreement to ask members to come forward and register who haven't yet registered. There is an agreement with the court after the notification of that registration period to close the class for a short period of time, usually at the mediation, and a short period after the mediation. And the rules will say, or those orders will say, if you register in this period and the class settles, then you get the ability to share in the spoils of that settlement. If you don't register in this period and the class settles, you are barred from bringing a similar claim and you do not get to share in the spoils. But if nothing settles during that period of time, effectively the soft closure ends. That's why it's called a soft closure, and the class is reopened again, and there'll have to be a registration period again at some point down the line. So that's a unique development in the Australian jurisprudence here. The fourth one is very key and very different between the Scottish and American systems and what we have in Australia, in that we do not have a certification process. I would suggest to parties who are on the defense side of these class actions that having a certification process is probably a silver bullet in a lot of cases. So in America, the certification process is quite stringent. There's quite a few thresholds, and most cases will fail at the certification stage in the US, and hence why a lot of class actions will settle in America for very small dollar numbers prior to certification. In contrast, we don't have a certification process in Australia. It is very easy to commence these cases. Mike has outlined the threshold requirements, and once those cases start, they're very, very difficult to stop. And usually it requires a pretty significant settlement to be reached between the parties, or alternatively us going to judgment. The final 2 points I'll raise are, we have a notice and opt-out period. So we have particular prescribed court timetabling, which says you must notify people and give them the option to opt out at a particular point. And if they don't opt out, they're considered to be part of the class, noting my comments about soft closure before and registration. And finally, as Mike has touched, unlike the Scottish system, we do not have contingency fees in any jurisdiction in Australia for class actions apart from in Victoria. And that has only been introduced in the last 12 to 24 months. It's called a group cost order. I don't think there has been a judgment yet in the Victorian Supreme Court agreeing to a contingency fee. There have been orders for the percentages that a judge might be willing to award should the case go to judgment, but there has not been any final decision on what an appropriate percentage is. We're looking around 25 to 27.5% is sort of the guide right now for the group cost orders that are being sought by plaintiff class action law firms in the Victorian Supreme Court, but that will depend greatly on the size of any settlement or judgment award. So that's a quick run through of just what I could identify as some of the key differences. As I said, I apologise, Craig, Stephen, and any Scottish lawyers on this call if I've misled anyone as to my lack of knowledge regarding the Scottish system.
No,
Stephen,
thank you.
over to you.
Thank you very much, David, and Mike and Craig for setting the scene. Now, I think that class actions, group proceedings have come into the kind of public, popular culture consciousness, and I think it did that a long time ago when people like John Grisham were writing books called King of Torts, where you have, you know, a personal injury lawyer in effect, kind of going about the country in private jets, signing up lots of people to a class. But I think that what the scene setting demonstrates already is that you have an increasing group of sophisticated users of class actions. And it's very useful, Mike, David, for you to just set out the sorts of class actions that are already forming or have formed and have been seen through to a conclusion in Australia. Craig, it might be useful if you could just maybe highlight, and I know it's early days in Scotland, but you know, the three kind of high level cases that have already found themselves into group proceedings in Scotland. Could you just very briefly touch on what those three cases are about, and we can maybe see if we can start to draw parallels with what's happening elsewhere in the world?
Sure. Well, as you say, Stephen, it's a nascent procedure in Scotland, and there's three that have been granted permission to proceed by way of group proceedings in Scotland, and they are quite different actually when you talk about them. The first one is the Volkswagen case, which relates to the alleged diesel emissions type claims against them, which is no stranger to many jurisdictions around the world, these types of cases. So that's effectively a consumer type action against a producer or retailer of vehicles. I'll come on to touch upon that. That was certainly the first one. The second one is a very interesting one, and it relates to claims by Kenyan tea farmers against a defender who is headquartered in Scotland. It relates to cases by employees, all Kenyan tea farmers, who've suffered a range of musculoskeletal, it's too early for saying that word, musculoskeletal injuries in the picking of tea leaves, presumably, and in Kenya. And the third one relates to sexual abuse claims against Celtic Boys Club, and linking that Celtic Boys Club with the football club as well. So there's a range of cases here, going from consumer to employee kind of health and safety, and then historic sexual abuse. So there's a very wide range covered there. And what we haven't seen is some of the cases coming through yet that David's highlighting and Mike was highlighting in terms of the shareholder type actions. And I'll come on to talk about that later if it's of any use. But in relation to those three cases, there's been some developments, because obviously what we've got in Scotland is new rules that are being tested in each of these three cases. It's being informed by some practice notes that have been produced by the Lord President. In the Volkswagen case, what we've seen in that is that the court is going to stick somewhat rigidly to the rules, certainly initially, and ordered compliance with the rules, particularly regarding service, where there's this double stage process, and courts are not going to dispense with that, certainly not without very good reason. In that case too, there was some consideration, and I know David touched upon splitting the group. In the Volkswagen case, there was some consideration as to whether or not the group could be formed as a whole and then split down amongst the various car badges, if you like. That seemed to be seen by the court as an effort to try and give a number of different individual pursuer firms the right to be the controlling party for those subgroups, particularly given it was such a big feather in the cap of proceeding with the very first group proceeding in Scotland. I can imagine that there might have been some competition to try and have your name associated with that. But the court didn't see the merit in, or certainly not the efficiencies in, creating a group and then splitting it up. But that might be something that happens in the future. David, just touching upon what you were highlighting in Australia. The next case that's provided some clarity and a point of distinction perhaps in relation to Australia is that in the historic sexual abuse group that's proceeding against Celtic Boys Club, Celtic Football Club, we're talking about very low numbers, certainly comparatively with the numbers you're looking at in some of the other group procedures, where it's maybe I think in the region of around about low 20s are forming that group. Now obviously that's over the magic 7 in Australia, but we're still talking about a very low number of people comprising that group. That is proceeding before the court, very different from the other two cases. Where we're getting a lot of insight as to how the court's going to treat these types of claims is in relation to the Kenyan tea farmers case, where we have had some decisions from the court in relation to, firstly, the representative party. In that case, it was initially proposed that the law firm acting on behalf of the group would act as the representative party, and the court decided that that perhaps was blurring the edges of where the group would be best served. And it was felt that it would be more appropriate, or that they certainly should go back and think again as to who they wanted to propose as the representative party. And they've now appointed a retired QC who effectively is acting as the representative party, is distinct from the law firm who is advising the group. And that's also the way that it's proceeding in relation to the Celtic Football Club group, where retired QC has acted as the representative party. That's not the same in the Volkswagen case, where it is just a consumer, an individual who has bought one of the affected Volkswagen vehicles. So there is a point of difference there, and that seems to be settling now. Whether or not we start seeing retired QCs finding this as a way to earn money in their retirement or not, I don't know, but it will evolve. But it seems to be stabilised at the moment, in that is finding favour with the court. And also in relation to the Kenyan tea farmers case, there was a challenge to the approval of the certification of the matter is appropriate to proceed by group proceedings. The argument, as I understand it, that was taken by those acting on behalf of the Kenyan tea farm was that musculoskeletal type injuries was so wide that it didn't really exemplify common issues of fact, and that found very short shrift with the appeal court in Scotland's the division, and it was, as I understood, dismissed without the pursuers grouping being asked to actually deliver any submissions. So that was closed down, and so that appears to hint at where the development is going in Australia, and that the courts will take a fairly loose approach to that certification of common issues of law and fact. So we might be in that Australian space, or certainly get to that Australian space, where the court's really just looking to see if there's a preponderance of commonality. The other interesting fact or development in relation to the Kenyan tea farmers case is that the defenders are extremely concerned that the action is being raised in Scotland as they would describe it, as a case of forum shopping, if you like. There would be no barrier, if you like, to those Kenyan tea farmers proceeding in Kenya. It's seen as a more favourable jurisdiction in terms of awarding damages in their favour in Scotland. And the only link is the headquartered, or the defenders are headquartered in Scotland. And so that was challenged unsuccessfully, and the group has been granted the right to proceed by group proceedings in Scotland. That was then sought to be effectively stymied by the raising of an anti-suit injunction in Kenya to stop the group from proceeding in Scotland by way of group proceedings. The Scottish courts have taken a lot of umbrage at that action and have effectively made their own direction, compelling the defenders to effectively put an end to that anti-suit injunction in Kenya. So there's been a number of skirmishes in relation to that Kenyan tea farmer case, which might be have its nexus in a far-flung destination, but it's providing a lot of insight into how group proceedings are going to progress in Scotland at this very nascent stage in their history.
Okay, thanks, Craig. That's interesting. I mean, that's, you know, you see David from another jurisdiction, you know, looking at our system and saying, look, you've got the certification process. It's a hurdle. It's still a hurdle for people to go over, though. David, you've heard there that the main classes forming in Scotland, consumers, employees, historic abuse cases. What trends are you seeing in Australia in terms of the types of classes that form? What sort of classes are you seeing? Are you seeing business classes forming?
It's a great question. So you have to look at trends over a number of years. Mike noted at the outset of the Australian section that we've had at least one class action system in place since 92 now, I think. So we're at 30 years. But the history of the Australian system is quite unique in that for probably the first 10 to 15 years, there wasn't actually that much activity. And the reason for that is litigation funding was not allowed for much of that period. And then in 2006, there was a famous judgment, the Fosdiff judgment, which sort of removed historic rules of champerty and maintenance, and litigation funding sort of got the stamp of approval. And that was the rocket ship that was required in the class action system. And what you then see is what I might refer to as class action promoters, but really I'm talking about, at least in the original 10 years post 2006, we're talking about class action litigation funders, that they try and identify the cases that are going to be the most economically viable for them, because at their base, they are a profit-making entity. They invest in the litigation process, and in Australia, the class action litigation process, with a view to making profit. And they put at risk their funds, usually by financing the case and by agreeing to provide security for costs and indemnity for costs and costs if they lose ultimately. And in return, they take a cut of any settlement amount or judgment award. So they're the instigators of that case. Now that's the start of that question, Stephen, because to really understand the trends that we've seen in Australia, you have to understand who's driving a lot of those cases, at least initially. So where did that lead us to? In the sort of late 2000s, we saw a real explosion of shareholder class actions in Australia. Now, they are very similar to shareholder class actions, securities actions in the United States, in that they seek to identify an alleged non-disclosure. As Mike mentioned, we have very stringent disclosure rules for the stock market in Australia. So they seek to identify an alleged non-disclosure, and they seek to identify a disclosure that is called to be the curative disclosure or the corrective disclosure that has led to a share price decline. And they say that share price decline is representative of the market reacting to this information. And that is the value of the information that you didn't disclose in an earlier stage. So cases started to be brought saying, if I purchased during a period of alleged misinformation or omission of information to the market, that is a period in which the share price of that company was inflated above its true value. And if I sold after the corrective disclosure when the share price has declined, I've suffered a loss because you've misled the market and I've purchased my security in reliance on the market valuing the information accurately. So the Americans use a phrase, fraud on the market. You've defrauded the market by not disclosing. So that's been for many years the engine room of class actions in Australia. And I would still say today, that is one of the bigger portions of the class action industry that we see. Now, a question's come up in the Q&A that I've seen, and it's relevant to shareholder class actions in that we've had a slight decline in those actions in recent years. And the reason for that is really government politics and regulation. So we've just had a changeover of the federal government. We now have a Labour government in power, but prior to that, we had a Liberal coalition government, effectively equivalent of the UK Tory party type equivalent. And what that government tried to do over a period of time was relax the continuous disclosure requirements on corporations, and B, regulate litigation funding more and more. And so there's a period of time over a course of 2 or 3 years where bringing continuous disclosure shareholder class actions in Australia reduced because they were less profitable for funders, and funders were more worried about the regulations that were in place. Alongside that, at the same time, what we have seen is a few years ago, Australia went through a Banking and Financial Services Royal Commission, very highly publicised Financial Services Royal Commission, where a number of banks and financial institutions went through publicised inquiries where lots of wrongdoing or alleged wrongdoing was identified. Off of the back of that, we have seen a huge number of financial services class actions. Now, I say financial services in the broadest of sense, but really they look to target unnecessary fees being charged to customers, for example, over particular products. So a good example of that is in Australia, we have huge superannuation systems, so effectively pensions, with massive pension funds. They are very big investors in a lot of stuff. And there's a required amount of money that has to go to superannuation funds in Australia, similar to the pension system in the UK. What was found in the Financial Services Royal Commission was that a number of superannuation funds were overcharging or charging fees to each of the members, which numbered in the hundreds of thousands for each fund, without actually providing any service. Now, on the back of that, a lot of class actions were brought against financial services institutions, banks, and superannuation funds for effectively charging fees for not providing the service or the service they said they were going to provide. So we've seen a lot of financial services. We've also seen the sort of consumer law cases that Craig has talked to. So he mentioned the Volkswagen case. We've had that case here. We've had the big automotive diesel emission fuels cases. We've had the airbags cases. Also within that product liability consumer law type sphere, we've had a lot of medical implant cases. So mesh was mentioned before. We've had a lot of mesh cases, and we still got some going on here. We had a period of time where we had big cases to do with hip and knee implants in Australia and mass harm. They got through the hurdles that Craig talked about as to how do you run these cases when you're talking about medical issues that are very individual things. There were lots of challenges, and we do have, I probably painted a system in Australia where there's no challenge mechanism. There is a challenge mechanism, but virtually all the time those mechanisms fail, because really, as coming back to the principle of it, the courts just need to find one common issue of law or fact. And so one question in respect of hips is, were they manufactured in a defective manner? That's the question that the court, not how did it affect each individual, but just as a core, was there some defective manufacturing? And that's enough for it to survive and go through. So we've seen a lot of those kind of cases. On the horizon and coming through now, we are looking to, there's a lot of discussion about climate change class actions and environmental damage type actions. The formulation of those actions is not set yet. My sense, my best guess, is that what we will see is securities continuous disclosure type class actions linked with environmental issues. Put simply, companies will be taken to task for making broad brush environmental statements. We have very green credentials, and then an event happens that proves that that might not be the case, and a share price decline occurs, and a shareholder class action is brought on the back of that. That's where I see this sort of environmental cases going. We've got some high profile data breach occurrences literally in the last few months. And it's been announced that one of those is going to go to a class action in coming days. So we'll see data breach class actions that deal with privacy laws. And crypto is probably the next big topic that we're going to see people generating class actions around. But coming back to my statement at the start, Stephen, it's really what is the economic vehicle for the class action promoters? How do they feel they can generate revenue and profit? And that'll probably be the entree to a number of these emerging areas.
Okay, that very interesting. Now, we were meant to kind of wrap up at 9:20, but we've got a couple of questions coming in. If it's okay, I'm going to just keep us going just until 9:30, and then we'll wrap up then. So another 10 minutes or so of discussion. Mike, we could bring you in. I mean, I think that at Brodies, we're certainly don't see ourselves as part of the kind of the plaintiff bar that brings classes together, and imagine that at MinterEllison you have a similar view, kind of a corporate defence type strategy that you put in place for your corporates. What sort of things are you doing with corporate clients to mitigate their position before court actions are even commencing? What sort of advice are you giving to clients?
Well, I think probably the most interesting thing that we do is in the same way that the plaintiff firms monitor stock drops, we do too. And that gives you a heads up of who might be a target. So we've just done some work here in a medical testing case where we're anticipating a potential class action. And so we're now working with our client to try and shore up a defense, understand why something happened, and sort of try and get ahead of where the plaintiffs are going. But to some degree, you can prepare, but you can't stop the plaintiff from launching. But trying to avoid the clients being taken by surprise is the real key. And I think part of that is also about staying close to our clients and just talking with them about how their business is going, to make sure that if there is a problem or something has gone wrong, we can think about what the legal implications of that might be in a class action context, and then alert them to the potential danger of that and steps they might take to at least prepare for it, so they're not taken by surprise and they are sort of ready for it should it happen.
And of course, you'll probably have noted from afar that there's been quite a lot of volatility in the UK market. And I think just yesterday it was announced that the French stock exchange by value had just overtaken the UK stock exchange for the first time since records began in the early 2000s. So that gives you just a bit of insight into what's happening in the economy in the UK. Craig, just on the back of some of the things we've heard about the Australian system, what are we seeing what sort of behaviour are we seeing by what we would class as the plaintiff firms in Scotland and the broader UK in terms of how they're forming classes, and how are we going about mitigating things for clients?
Sure. Well, I suppose the success of a class is very much determined by the book that they can build, and so we are seeing, certainly from the Scottish perspective, groups of pursuers, solicitors going around and collecting names of those individuals they might think can form a class. So we're seeing the advertisement of that. We're seeing more sophistication in terms of the litigation funding models that are out there across the UK and moving into Scotland, because obviously the bigger a class can be, then the more bang that the litigation funders get for their buck. So that is, as if, I suppose, a more sophisticated outlook in terms of the way that litigation proceeds. It's now seen as an industry in itself, and I suppose it perhaps hadn't been seen as that in Scotland previously, but that's certainly what I view happening in Scotland. What we are doing with our we're reaching out to them to make sure that they are positioned as best as possible to react to any threatened group proceedings, making them aware of the steps they can take in a practical sense to minimize those risks. For example, even just as simple as lodging caveats in the Court of Session, so they get an early warning as to actions being raised against them or threatened in a group proceedings sense, considering their insurance policies, considering who will form the team that responds to the actions once threatened. But crucially, actually thinking about what it is that they're doing. So we're pushing out a lot of blogs, etc., in relation to awareness of evolving classes and how that might affect the way that they conduct their business. Particularly the financial services market, but also those impacted by ESG considerations. What is our product actually doing? Does it comply with what our customers are expecting? And if not, that's ripe for being picked off in the form of group proceedings. So I think in Scotland, it's making clients aware of this new development, where they are more susceptible to potential actions by way of a group than they might have been, particularly if those claims individually might have been low value.
Okay. David, you mentioned that the climate change, the potential for class actions on climate change. And certainly in Europe, we've already seen more of what I would call declaratory actions being sought, rather than it then making its way into damages. Damages, is that going to be an issue in Australia in terms of how do you formulate damages related to climate change type or ESG type claims?
Yeah, look, I think the answer to that question is yes, for the reasons that we've traversed today. The instigators of these actions and the first movers of these actions are usually the ones seeking profit, seeking to make profit. And it's not immediately obvious why a particular breach of some environmental standard would resonate with or lead to huge damages awards for a particular class, unless, of course, the breach of that environmental standard has caused some kind of toxic tort or environmental disaster. That's a different type of case. But with the cases where you have financial institutions or corporations that are listed that have said, we have ESG credentials, what you need to do is you need to identify one where the breach has occurred, i.e. that's misleading or it's not true, and two, where the loss has been suffered, and it's the loss that's the hard bit. And that's why I have a strong belief, and I'm already seeing this in the US, that they'll start at least on this route with stock drop type class actions. They're easier to bring, and once they get a bite on those, they'll move to broader penalty type issues where they can identify a harm, even a de minimis amount for each individual, but ramped up to 10,000, 100,000 people, it becomes a very significant sum.
Yeah. Okay. Well, we're just about on the hour mark. We've got a bit over, but I was certainly finding the discussion very interesting. I'm sure we could discuss this a lot further. I maybe just want to leave everyone with the headline in the Lawyer magazine just last night, and it says this: that the future of data class actions. A year after the Supreme Court's decision in Lloyd v. Google, which led to a long pipeline of data claims being dropped, claimant firms are now anticipating a bounce back. So I think that we can all safely say that class actions and group proceedings are here to stay. I think that due to the nature of data, ESG obligations in companies, that still a global marketplace, despite what some might see as a little bit more protectionism in certain economies. You can have group proceedings claims in multiple jurisdictions at the same time, and that's certainly something that we are seeing. So I would just like to thank everyone for their presentations today, and also thank you to everyone for joining. And I'm going to bring this session to an end. The key contacts are displayed if you'd like to send in any further questions. Thank you.
Thank you.
Thanks, Phil.